Today's topic is, what are the stages of a felony case here in San Diego County? Now, if you've recently been arrested on a felony case, or if you have a loved one going through the process, stick around. I think you're going to like this video. My name is Dodd. I've been a criminal defense attorney here in San Diego for the past 18 years. In the next few minutes, I'm going to explain to you the process of a felony case here in San Diego. Now, a lot of people get arrested for a felony and they think at their arraignment, which is your first court appearance, all your witnesses are going to show up and that's where you're going to present all your evidence. And that's not what happens. So typically what happens is in a felony case, you have an arraignment. At the arraignment, you plead not guilty. It's just a standard procedure to plead not guilty. Why? Because your attorney is not going to have any of the discovery, any of the police reports. So you plead not guilty, then you're going to get a new court date. You're either going to be in jail or you're going to be out of custody. If you're in custody, your attorney can then set a bail review to make a pitch for you to get out of jail at the next court date. If you're out of custody, then you're going to get a new court date. Now, I have separate videos on each of these topics I'm going to talk about. I have a separate video on an arraignment. You can like our channel, subscribe to our channel, and watch all separate videos in their entirety. But in this video, I'm just going to lay out the stages of a criminal case. You have the felony arraignment, and then you have a possible bail review. If you're out of custody, then you're going to have a readiness conference. If you remain in custody, you're also going to have that readiness conference. Now, a readiness conference is basically a nice term for saying settlement negotiations. The attorney, the judge, and the prosecutor are all back in the judge's chambers. The judge's chambers is a fancy word of saying the judge's office. And we're back there, we're discussing the case. The prosecutor typically, gives us some sort of plea bargain. We're discussing the case with the judge, with the DA, and then the defense decides whether they're going to continue the case or whether the case is going to settle. So the case could settle at the first readiness conference, or the case can get continued for multiple readiness conferences because the defense still does not have everything they need to move on to the next step of the case. We might not have video surveillance. We might not have video interviews. We might not have DNA evidence. We might not have certain discovery that the prosecutor is required to turn over. Now, if the case does not settle at a readiness conference, then there's going to be a preliminary hearing. So the case can settle at the readiness conference, and then you're going to have a sentencing at some future date. If the case does not settle at the readiness conference, you can continue it for another readiness conference, or the case can go to a preliminary hearing. So if the case goes to a preliminary hearing, I have a separate video on what a preliminary hearing is. It's a mini trial. The judge, the witnesses, the prosecution, and your defense attorney. You present the evidence, and then it's a very low burden of proof where the prosecution is going to put up all their witnesses. The defense is not going to do anything other than cross-examine witnesses, and then the judge is going to decide whether there's sufficient evidence for the case to go to trial. 98% of the time, they're going to find that there's enough evidence for the case to go to trial. So the case then gets put over for another court date. It could be another arraignment, or you can do the arraignment on the day of the preliminary hearing, or it's going to get put over for another readiness conference. Now, remember, after the first arraignment, we had a readiness conference. Now, after the preliminary hearing, we're going to have that readiness conference, settlement conference again. And at this point, the attorney can decide whether or not they want to file certain motions, 995 motions, other motions that your attorney may file. The prosecution might give you another deal at the readiness conference. And at that next readiness conference, if the case does not settle, then your last stop is a jury trial. And a jury trial is the last stop. You're either convicted by 12 or you're acquitted, or it's a hung jury. And if it's a hung jury, then the case could get tried again, or the prosecution can give you a better deal that your client decides to take, or the case perhaps could get dismissed. Unlikely, but there's also a possibility that the judge on their own motion can dismiss the case. So felony arraignment, bail review, readiness conference, preliminary hearing, another readiness conference, motions are filed, then we have a trial. If you pled at the readiness conference, you're going to have a sentencing as well coming up. If you have any questions, go ahead and give me a call. My name is Dodd. I've been doing this for almost 18 years. You can hit that like button. You can subscribe to our channel. Have a great day.